Good afternoon and welcome to this book celebration. This is one of the, for me anyway, one of the most meaningful events that the law school puts on, where we get a chance. And this project is significant and meaningful because it in fact is a project that has and will continue to make a real-world difference in the lives of millions of people. But to get us going, what I'll do is I'm just going to introduce my fabulous colleague, Larry Helfer, and then he will introduce his co-authors as well as the book project. So Professor Laurence Helfer is the Harry R. Chadwick Senior Professor of Law here at Duke Law School, obviously. He is an expert in the areas of international law, institutions, international adjudication, and dispute settlement and human rights, including LGBT rights, and in intellectual international property rights. He is the co-director of the Duke Law Center for International and Comparative Law and the senior fellow with Duke's Keenan Institute for Ethics. He also has served and continues to serve as a permanent visiting professor of law at the I-Court Center for Excellence in International Courts at the University of Copenhagen, which awarded him an honorary doctorate in 2014. If you haven't had a class with Professor Helfer, he's definitely a must-take. And if you don't know him, he is a tour de force. And for those of us who have interacted with Larry, it is one of the most things that is an absolute lasting impression. I mean, I love Larry and love his energy, love the things that he does. So it's my honor and pleasure to introduce him and then to have him introduce the co-authors, Professor Larry Helfer.
Thank you. Thanks very much, Guy, for that generous introduction. I'm really privileged to be here with my co-authors of the World Blind Union Guide to the Marrakesh Treaty, facilitating access to books for print-disabled individuals. I have worked on the intersection of human rights and IP, as I'll say in a moment, for a number of years. I thought I was done with it until I received a call out of the blue about 18 months ago from Ruth Lokedeji, who is sitting to my left, who is currently a chaired professor at the University of Minnesota, and in about a year or so will be taking up a chair and co-directorship of a center at Harvard Law School. And Ruth called me and said, well, you know I was involved in the negotiation of this Marrakesh Treaty. And I said, yes, I do, and I've been remiss in not really following, what's been happening with Marrakesh. She said, well, I think I can solve your problem because the World Blind Union, which is the leading NGO in this area and was a major proponent of the treaty, would like me, along with others, to prepare a guide to interpretation and implementation. So I immediately said, okay, that's really intriguing. And so I said yes. And she said, oh, and by the way, we'll be working together with Molly Land, who is immediately to my right, who is a professor of law and human rights and a member of the Human Rights Center at the University of Connecticut, and also with Jerry Reichman, who I imagine many of you know, who is, of course, a professor here at Duke and one of the founders of the field of international IP law. So with that in mind, they will present a variety of different perspectives. I'm going to just open things up. We'll speak collectively for about 40 or 45 minutes and then open it up for questions. As Professor Charles said, there'll be copies of the book outside. We deliberately priced the book very low in price, or as low as we could get Oxford University Press to agree to. We also were insistent that the guide be available online in full text in accessible formats on the WBU's website, the World Blind Union's website. So you should be able to access it there as well in making a statement against interest. If you're not so inclined to purchase a copy. So let me just say a couple of words about, first, the relationship between human rights and intellectual property, and then secondarily, some of the legal and factual backgrounds leading up to Marrakesh. Professor Lokedeji will then take over to describe the negotiations, some of the key tension points in the negotiations and in the text. I should also say that she was the negotiator at Marrakesh, one of the key negotiators on behalf of Nigeria and the African group. So she can give a very much of an insider's perspective, at least as much as she is comfortable doing with respect to the negotiations. Professor Land will talk more about the guide itself, how the guide takes various positions on what the treaty means and how it should be implemented, and how it's really a fusion of human rights and IP, at least in our vision. And Professor Reichman will, let me just be absolutely clear, say, a couple of words about what is known in international IP circles as the ubiquitous three-step test, which is a test for restricting exceptions to copyright, of which the Marrakesh Treaty is one important one, and also perhaps talk more, he will, about some of the future ways in which this treaty might serve as a model for other sorts of international lawmaking initiatives or regulatory initiatives. So, in very brief terms, the relationship between the body of law of copyright, trademark, patent, trade secret on the one hand, and the fundamental rights of individuals and groups on the other, for many years were largely separate spheres. They really didn't relate to each other in any meaningful respect, and this was notwithstanding the fact that actually there are some provisions in international human rights law, in the Universal Declaration and in one of the foundational covenants on economic and social rights, on the issue of the rights of creators, and linked to those, the rights of the public to share in scientific advances, to share in scientific progress, to have access to the fruits of their creativity. So the kind of balance that intellectual property law tries to strike between incentives for private innovation and creativity on the one hand, and access to the fruits of that creativity and innovation on the other, are shared by human rights law, at least at the foundational level. But the details of how those regimes intersected had long remained unexplored. And when they first began to be explored in the context of the UN human rights system, this is around about 2000, the initial response was, I would say, pretty categorical. Well, if there's a conflict between intellectual property and human rights trumps. Human rights are fundamental, they're inalienable, they are not bestowed by the state as a matter of grace, and so if there's an intersection between them, human rights wins. Well, there are a number of problems with that approach, not the least of which is that it's very hard to find a real strong conflict between these two regimes. There are conflicts in a policy space, and it's also not entirely clear how one actually conceptualizes this conflict as a legal matter and what its scope actually is. But what this approach actually did do, I think, is to catalyze thinking about how human rights and intellectual property relate to each other. And a second approach, I think, emerged fairly quickly, other than this conflicts approach, one that had human rights primacy as its endpoint. And it was one in which the two regimes mostly coexisted. That is, the two were sort of aimed at the same ultimate goals, but they maybe got there in different ways. And the result was, I think, in a helpful way, kind of reinforcing for government officials and for civil society the importance of exceptions and limitations to intellectual property rights, including copyright, and the importance as well of using these flexibilities in the existing international legal instruments as ways to balance the protection of IP on the one hand and other important societal goals on the other. So that's where things kind of stood. And I've written about that intersection, as have everyone else at this table. And I think there was some dissatisfaction at the end of the day with that. And, you know, I was searching for ways to think about how one could move beyond these approaches of conflict or coexistence. And I think the Marrakesh Treaty does that in the following way. It actually achieves a kind of marriage of these two fields, and in the way we describe in the guide, uses the legal and policy tools of copyright law to achieve human rights ends. So how does it do that? Well, Professor Okediji and Professors Land and Reichman will say more about that in a moment. But in brief, it uses the existing structure of the international intellectual property system and the possibility for exceptions to coordinate around a global model that would have all countries adopt these exceptions for the benefit of these particular individuals, those of who are blind or otherwise visually impaired or print disabled. That's a broad category, actually. And allow for these exceptions to permit the sharing of alternative format copies across borders. And I think to transition to why this treaty even was conceived of as being a possibility, you have to, I think I have to really give credit here to disability rights organizations, including the World Blind Union, for highlighting the tremendous challenges that people with visual disabilities face around the world, especially in developing and least developed countries. So there are some nearly 300,000 people around the world who are blind or have visual disabilities, and only 5% or so of published works are available in accessible formats. And that's really a tragedy, especially when you consider that accessible formats today are not the very thick books of Braille that you may have occasionally seen. They are still those, but they are also especially a variety of different accessible electronic formats. E-Braille exists, as well as a variety of technologies for converting text to speech, text to audio, screen readers, large print books, a whole range of accessible formats. And what that technology, basically the internet, standard internet technology and its applications made possible, was the idea that you wouldn't have to have every country in the world creating its own repository of accessible format materials in different languages, local languages, languages shared with a former colonial power, whatever the case may be, that you could create a mechanism for creating and exchanging accessible format copies in ways that would allow countries to serve each other's needs. And so what the World Blind Union did was label this problem that I've described, the number of people affected and the paucity of printed materials available, as the global book famine. And that was really, I think, part of what led up to the possibility for the treaty. Two other quick points before I turn things over to Professor Okediji, and that is the disability rights groups, human rights organizations that focus on this area have been very active for a number of years. And in 2006, they pushed forward with what is now a very widely adopted international agreement, the Convention on the Rights of Persons with Disabilities, or CRPD. And buried in the back of that agreement, I discovered one day, I didn't know about this when the agreement was being negotiated, is a provision that requires states, states parties, of which there are now some 170 or so, to ensure that laws protecting intellectual property rights do not constitute an unreasonable or discriminatory barrier to access by persons with disabilities to cultural materials. So there was a template in international human rights law to build on that very spare clause to provide a kind of global infrastructure for creating accessible format books and cultural materials and sharing them across borders. And when that became known, and when it also was clear that many of the countries in the world that had these exceptions already in their national laws were some of the strongest proponents of copyright and IP rights, the US, the EU, Canada, et cetera, it then became politically even conceivable to think about having a treaty that would have mandatory exceptions to copyright to benefit people with visual disabilities. Let me turn things over to Ruth.
Thank you so much, Larry, and thank you everyone for being here. It's such a joy to be back on the Duke Law campus. I sort of count this as a second home, sometimes even a first home, given how many of my dear friends are on the faculty here. So I'm really glad to be back. Professor Helfer has, as always, done a masterful job of condensing a lifetime of work for him, and a huge field into some really key points that set the groundwork for the Marrakesh Treaty. On the slides that I will show you at the end of my brief comments, just to give you a sense of the dynamics during the negotiations, but also of what it takes to create an international treaty that in many ways has set a precedent, but is also unprecedented in the field of intellectual property. Let me talk a bit about a few things. What does it take to make an international agreement of this sort? Professor Helfer's comments identified the trajectory of events, both in the field of international human rights law and in the field of international copyright law, these two fields really developing, maturing in isolation, making it difficult to conceive of a time and a place and a moment where they might intersect or in fact converge. And the Marrakesh Treaty does all of those things. And I like to think of the treaty itself as something that reflects both the coexistence model as well as the conflict model. Different parts of the treaty really work in both of those realms. And then there are entirely new parts. So think of it as a renovation where you keep the bones and you sort of move things around to accommodate new interests and to create new instruments legally that facilitate the goals of the demanders. Now, I always like to start with how many of you are wearing contact lenses in the room? All right, great. So if you added those who are wearing contact lenses and those of us who are wearing glasses, there's about 90% of the people in this room would qualify as being visually impaired. And I say that to say that often the treaty is thought of as a treaty for the blind. It is in fact not just a treaty for the blind, it is a treaty for visually impaired persons. And what it does is that it guarantees a fundamental liberty interest. If you chose not to get corrective surgery, if you chose for any number of reasons that it was not feasible for you to take corrective measures so that you could become fully sighted, the Marrakesh Treaty actually preserves that choice. And that's one of the aspects of the treaty that I think is rarely talked about, but also not quite visible in the labyrinth of provisions that really delve into the technical details of the treaty itself. And so, no pun intended, getting this treaty done required the right vision. It required the both the vision of the World Blind Union to anchor on to what had already been established in the Convention on People with Rights, for the Rights of People, Persons with Disabilities. It also built on really the growth and the development of international human rights law since the end of the Second World War. The idea that there are circumstances in which states ought to exercise their powers of sovereignty to respond to the needs of discrete groups of individuals. And so there are actually multiple layers and themes in international human rights literature that resonate in this treaty. It also required a visionary, required a coalition of interests that could push successfully at how to frame and position the demand for a treaty at the World Intellectual Property Organization. And it required a voice of public conscience. It's one of the interesting things to me, having been involved in the negotiations, to see how at different points each of these actors had to play a very specific role in articulating the legal and the normative basis for the treaty itself. So let's, talk a little bit or take a few moments to talk about the aims of the Marrakesh Treaty and then the origins of the guide, because I think that one of the things that the international copyright system does less well is to, in fact, make the cross-border exchange of creative works possible. We think of the international system for copyright protection as a system that creates the infrastructure, creates the framework for that happening, but doesn't mandate that it happens. And so there are lots of ways in which in the non-Marrakesh Treaty context, you may want to make copies of a book in Algeria, or you may want to make copies of a book in South Africa, or you may want to, for example, translate that work into a language for a particular community to access, and copyright law would actually prevent that. What the Marrakesh Treaty does, and what the World Blind Union Guide advocates, is the use of human rights objectives as the endpoint for this transformative vision of international copyright law that we see in the Marrakesh Treaty. What it ultimately allows for is the making and distribution of published materials in formats that are accessible to people with print disabilities. In fact, one of the key ways of moving several countries that were skeptical, somewhat recalcitrant about the treaty, was to make the argument that this was about equal treatment. In fact, the World Blind Union itself made the argument, we don't want to be treated better than sighted people. We want to be treated equally. And to the extent that what makes us have access is a format that we can read and print and distribute just like a sighted person, we are entitled to this as a fundamental human right. It was an equality argument that ultimately drove the European Union in particular, for example, which of course is, if you've taken any of Professor Helfer's classes or you're a student of public international law, the history of the European Union, in particular, its brand of human rights jurisprudence and its commitment to the goals of human rights, much more emphatic than we might see otherwise in the United States. It was a powerful argument to advocate to get the EU on board politically with the idea of a treaty that would create a mandatory exception to something else that has been conceived as a human right in the European context, and that's intellectual property. And so what the treaty ultimately does is it creates mandatory copyright exceptions to enable the creation, the importation, the exportation of copyrighted works that are accessible to blind and visually impaired persons. The primary importance of the treaty is this enablement of cross-border exchanges of accessible format copies. It's quite important, I think, to note that it was clear during the negotiations that countries were going to, out of pride or out of shame, be forced to sign this treaty. They were going to sign it at Marrakesh. Now, whether they would implement it and ratify it was a whole different story, but we knew that the advocacy on the human rights front and the arguments that had been made throughout the process of negotiating this treaty would compel countries, for fear of NGOs in particular in the Black community, pointing them out as exemplars of bad behavior, the reputational effects of that and the concerns about that was going to create at least a political consensus to get us over the hump. And so in Marrakesh on June 28th, we signed the treaty. These pictures actually are after the negotiations, which is why everyone is smiling, as you will see. Now, two things that I want to point out, some key provisions, and then two things that I want to point out before I show you some more pictures. What are the mechanics of the guide? What actually makes this work? If you've had Professor Reichman's classes or taken any of the classes on international intellectual property law here at Duke, you will know that the standard architecture of international IP treaties are minimum rights with very little exceptions and limitations built into those rights. So mandatory minimum rights that copyright owners, patent owners, trademark owners are entitled to these rights. And of course, a principle of non-discrimination, which was not in the Berne Convention originally, but we saw that, of course, married in the TRIPS agreement, so that foreign authors get the same treatment in Morocco as Moroccan authors, right? The principle of non-discrimination, so national treatment, and most favored nation principles. So the principle of non-discrimination and mandatory protection of the rights of authors have been the fundamental pillars of the international copyright system. And the Berne Convention, as it evolved throughout the 19th century, included provisions in the text, as of 1971, the Paris text, that also prohibited countries from entering into any international agreement that would deviate or dilute in any way the minimum rights of authors. So here you have these mandatory minimum rights, very little exceptions and limitations, human rights law being developed in complete isolation, and then you have these provisions in the Berne Convention that said, and by the way, you signed the Berne Convention, you also are agreeing that you will not participate in any international agreement that will minimize or in any way dilute these rights. Which meant, of course, as Professor Reichman will speak on in a few minutes, that there was this provision in the Berne Convention expanded in the TRIPS agreement that said any exceptions and limitations to the rights of authors had to be justified. And there were only very narrow grounds, at least as conceived by the European Union, only very narrow grounds on which you could justify those exceptions and limitations. So there was already a rich literature and a rich history to overcome this idea of a mandatory exception and limitation to copyright rights. So one of the key challenges during the negotiations, and one of the key things that we spend a lot of time on in the guide, is how do you reconcile this notion that there can be mandatory exceptions that are consistent not only with the human rights of authors, but also the human rights of users, and in particular, the human rights of the visually impaired. And so there are really three core provisions that we go through in the guide and that are central to the treaty itself. Article 4 is where you see the mandatory expectation, the requirement that you have exceptions and limitations to copyright rights. And then Articles 5 and 6 that deal with the export and the import of accessible format copies by beneficiaries. Now, one of the things that I think was quite interesting, of course, is that when you think about where visually impaired persons live, 90% of visually impaired persons live in developing countries. India was the first country to ratify the Marrakesh Treaty, but it had already modified its copyright laws to be consistent and to preserve an exception for accessible format copies by users. Now, the equality argument that I mentioned earlier was critical because blind people in particular, not just visually impaired persons, but all the way to the spectrum of being blind, are well less educated even in the United States. In fact, one of the things that was critical for several congressmen who backed this US participation in Marrakesh is the fact that when you look at the research in the United States, blind adults on average in the US had only slightly over 11 years of education. Now, I've had the privilege of teaching students who are visually impaired and students who are blind in law school, and I recall my first experience with that was so frustrating because my student was always 6 weeks behind in the readings. That's how long it took for us to get permissions, to adapt, to get things, case books turned into Braille, to then get that available to my student. And so you could see, in fact, I think I've only had one student who was blind who successfully completed law school in 4 years. The others ultimately dropped out. And a lot of that is the burden of accessing material. So today, with the Marrakesh Treaty in place, we had safe harbors discussed in the guide, where those safe harbors, in essence, create they create a presumption of validity in what countries choose to do in how they implement. If they follow the literal language in the treaty, countries can presumptively feel like they are on safe ground, and that's important. 40%, of course, of blind persons did not have a high school diploma, and only 12% had some form of a college degree. Now, when you think about the impetus for the treaty, WIPO ended up doing a survey. At the national level, about 60 countries who are members of the World Intellectual Property Organization had these copyright laws that specifically mentioned the blind. But almost all of those countries did not allow for the export of those copies. So if you were visually impaired and you were in Sao Paulo, you had a good friend in London, you could not export a copy of a book to your friend in London or vice versa. And so the treaty, of course, in Articles 5 and in Article 6 mandate that, and one of the arguments we make in the guide is that the implementation of Articles 5 and 6 should be to ensure that those exchanges are facilitated both as a matter of private use, that is individuals. In other words, the Marrakesh Treaty doesn't take away from existing exceptions and limitations that are already in the Berne Convention. In fact, what it does is it adds to them. We think, as we explain in the guide, that the Marrakesh Treaty and our approach looking at it as a human rights instrument ultimately restores flexibility to nation states in how they implement the provisions of the Marrakesh Treaty. And it also, of course, does something that we don't see in the TRIPS agreement, which is it allows the possibility of other agencies, in particular human rights agencies, to get involved with the process of administering essentially copyright rights. It takes away a little bit from the idea that there's only one government agency that can deal with intellectual property, in particular copyright, and that's the Copyright Office. With the Marrakesh Treaty, human rights, national human rights offices can now be involved in assessing the impact of intellectual property rights on persons who are visually impaired. So my time is up, and I thought I would just show you a couple of scenes from Marrakesh. At the top there, actually, she is the ambassador, was the ambassador of Uganda. One of the things that happens when you're negotiating international treaties, the experts do kind of all of the gut work, working through the technicalities, but you actually cannot sign off on anything without the political agreement of the ambassadors. So all the ambassadors had to be flown to Marrakesh, and here is the ambassador of Ethiopia. I'm not sure if my laser is working, but to your right, or to my right here, is the ambassador of Ethiopia, then of course the ambassador of Uganda, the ambassador of Sierra Leone in the purple t-shirt, and then the Kenyan ambassador. Valerie, the woman in the middle there, was the WIPO translator. And I cannot say enough how important the work of translation is in international negotiations, because getting the word right, ultimately when national courts are looking at these texts, they are relying on the work of the translators. At the bottom here, well, because of time, I'm going to skip very quickly. These were the key negotiators. When we reached an impasse, it took really Justin Hughes, for those of you who know Professor Hughes, who's a law professor, copyright law professor at Loyola University, Kenneth Nobrega, the Brazilian negotiator, Maria Martin Pratt, the European Union negotiator, Mokhtar Warida, the Egyptian negotiator, and G.R. Raghavendra, the Indian negotiator. These countries were especially important. It was very clear that India, having just gone through a massive copyright revision, was not trying to sign any treaties that were going to undo what it had promised to its very large population of visually impaired persons. Maria had all of the countries of the European Union had to be in agreement for her to move on anything. So she was doing multiple levels of negotiation. Mokhtar Warida was the chair of the Africa Group. 54 countries had to be in agreement before he could say yes to any provision, every comma, every period. So these folks were working round the clock. Oh, well, that's just me. And the World Blind Organization, Union in particular, and all of the organizations for the blind do not have a lot of political capital. It became really important to have a public face to make this campaign a public campaign. Stevie Wonder became the face of the campaign and was flown to Geneva a couple of times. And he made the promise that should we get an agreement, he would come to a concert in Marrakesh. That is the Secretary General of the World Intellectual Property Organization. Mr. Wonder appeared over there, and he became a big voice, actually, in making sure that the process of coming to yes was significant. I'm going to stop there because I want to hand over to Molly to talk a little bit more about what's going on in the guide and our approach to it.
Thank you. Thank you. I've said this before, but just to reiterate, what a pleasure it's been to work on this project, and to also reiterate something that Larry said earlier, that this is really an incredible opportunity. Having studied the intersection of intellectual property and human rights for some time, it was really a chance to see, for me, a marriage of theory and practice, right? How could we take some of these conceptual problems and resolutions that we've been working on for so many years and try to apply them to a very specific concrete context. And I've been very delighted with having that chance and look forward to seeing how the discussions continue further. So the purpose of the guide, when the World Blind Union approached Ruth, and then Ruth approached us to try to put together something that would talk about how the guide should be interpreted, it was because the WBU realized that the implementation and interpretation of the guide was going to be critical. We have an incredibly strong treaty. It has good bones, but there are many different interpretive choices that states will need to make when they put this treaty into practice. And the World Blind Union wanted to ensure that there was a human rights voice talking about how those provisions should be enacted, that there was a set of interpretations out there to help guide states in making some of these choices. So what we tried to do in the guide was to articulate some of those policy positions that we thought were informed by the text and context of the treaty and the way in which it was positioned between the human rights and intellectual property regimes. So there are a couple of things that I want to mention here, and then I'm happy to talk more about any of this in the discussion. But the first sort of policy position, or one of the main policy positions we articulate is, as Ruth mentioned earlier, that the treaty is really a floor, not a ceiling, that it's a supplement or clarification, and in some instances an expansion of existing exceptions and limitations to copyright, but that it doesn't take away from authority that states have, other flexibilities that they have under intellectual property treaties or under national law. So it's not a replacement or codification, but rather an expansion and supplement. The second sort of issue that we struggled with was to try to understand the object and purpose of the treaty, because for those who've had international law, international human rights law, that's really the guiding sort of touchstone for how it should be understood and interpreted. And we were faced early on with this question about is the treaty really about furthering the rights of persons with print disabilities and intellectual property owners? Or was this a treaty really about understanding and promoting the rights of individuals with print disabilities within a context in which the rights of intellectual property owners were already established and created? And so it was, to my mind, a question of whether the treaty was about articulating a balance or was it about promoting a balance. And we ultimately, in thinking about the context in which the treaty was created, the existing protections that are available for intellectual property owners, including through the three-step test, which appears in the treaty in multiple places, we concluded that its primary purpose was really to restore that balance, to really inject some more flexibilities, at the same time while reaffirming and acknowledging these existing protections. And this was very helpful in articulating early on because it allowed us to read the provisions of the treaties when there were policy choices to be made in a way that we thought would foster and promote the goal of trying to create the most enabling environment for individuals with print disabilities. So there are a couple of interpretive conclusions that we discuss in the guide that I just want to highlight here by way of a sample. For example, one of the things that we look at in the guide is the definition of beneficiaries. We talk about the fact that the treaty is not just for individuals with visual impairments, but rather individuals with cognitive disabilities or physical impairments that prevent them from reading or holding a book. So in order to maximize the availability of rights under the treaty, we encourage states not to adopt a medical definition, but rather a functional definition of beneficiary that makes those rights available to anyone who cannot access print materials to the extreme ability as individuals without those disabilities. We also address the question of authorized entities. Now that's a sort of a term of art in the treaty at this point, but the sort of backstory is that in the discussions, and actually maybe Ruth, you can talk about this more, there was really a desire, especially on the part of intellectual property rights owners, rights holders, to have some kind of gatekeeper, right, in the context of making and distributing accessible format copies. The treaty really it takes a compromised position. It recognizes that authorized entities are those organizations that facilitate access to print materials for individuals with print disabilities, and they will be involved in the creation and sharing of accessible format copies, but that they are not the gatekeepers. They're not the only ones who can do this. Beneficiaries themselves can create and share accessible format copies. And in addition, authorized entities aren't subject to licensure requirements by the government. The government may create regulations, but authorized entities are not, under the treaty, required to go through those licensing processes in order to create these copies. And the reason we really emphasize the importance of a broad definition of who can make copies is because setting up gates and licenses and procedures would really put an undue burden, particularly on organizations in the developing world, but organizations everywhere that might be chilled from making accessible format copies because they don't know if they meet the government regulation, or maybe the government is slow in creating those licenses or giving them out. So we really wanted this to be, in the guide, we really take the position that in some ways the treaty is a self-implementing treaty, right? That all the government has to do is simply create the exception. It needs to step out of the way. And beneficiaries themselves, the individuals with print disabilities, and organizations that serve their needs, whether those be libraries or organizations for the blind, they can just go ahead and create accessible format copies, Braille copies or DAISY copies to be used in e-readers, and then they can share them as well. And the benefits, the actual cost savings of that cross-border sharing are actually tremendous. I was just reading this morning that it's something like $2,000 per book in many instances that you can save simply by allowing an organization that's in Australia that has a copy of this work to send it to another organization that serves beneficiary persons in Canada. So we take some positions about beneficiaries and authorized entities. And then the final part of the guide, we also talk a little bit about implementation. Again, the idea of implementation is that it should be easy, hopefully, in many instances to begin this process. States need to create an exception to their copyright laws, but they don't need to create new mechanisms, new institutions to facilitate this. It will hopefully be driven by beneficiaries and their and authorized entities themselves. It does, we do recommend that there be, we bring a couple of human rights principles into the implementation in a couple of ways. So the implementation of this treaty, we think, will look a little bit different than the implementation of an IP treaty. We argue that because it is achieving human rights goals, that it should also be implemented in consultation with affected communities. That's a very strong principle of human rights law. We also encourage states to monitor whether organizations and beneficiaries are making use of the provisions of the treaty to ensure that, for example, rights aren't being chilled through overzealous litigation. But we encourage states to use existing mechanisms rather than create a new treaty, and actually rather than charge an IP office to do this. We really do encourage states to involve national human rights institutions in these processes. These are institutions that are already charged with these kinds of topics. They're already involved in processes of monitoring with the United Nations and United Nations treaty bodies. So we emphasize the importance of taking proactive implementation steps, but that hopefully there will be existing mechanisms that can be used to do this in a way that really involves beneficiaries themselves in the implementation of the treaty. Now, there are a couple of other policy choices in the treaty that I think Professor Reichman was also going to speak about, but I look forward to questions about any of those provisions as well.
Well, for the first time in my life, I feel like a free rider compared, my contribution compared to what Ruth, Larry, and Molly have done. But this is a remarkable treaty. Its most innovative feature is the cross-border supply of books and materials by designated authorities. Normally, intellectual property law is always territorial. Even the TRIPS agreement refers its harmonized copyright standards back to the states that have to implement them. And here instead, this breaks with territoriality. The suppliers, the authorized entities in state A, can effectively supply the needy beneficiaries in state B across the border once everybody implements this treaty. And I think that here is something really new and promising for international law, especially international IP law, because we have on the pharmaceutical side similar problems and similar blockades, and I believe this could be a map for breaking some of the impasses that we have there, which I can't go into now. Now, you shouldn't think, I would have loved to think that the publishers were kind and gentle, having fought with them in the WIPO copyright treaty, that they would have just laid down and purred here. Instead, they were more vicious than I've ever seen them. And as a result, there are some, and that's saying a lot. So there are two possible breaking points in implementing the treaty that have to be taken into account. One is there was an optional clause for a market failure clause. If the government is foolish enough to adopt that clause, then there would have to be evidence that the publishers are not sufficiently supplying the market for the blind before you could trigger the treaty, and that could end up in a lot of stories. But that is an optional clause. The second thing that the publishers did has to do with this, something called the three-step test. At the Stockholm Conference to revise the Berne Convention in 1967, they finally agreed on how to formulate a exclusive right, finally, for publishers, and the cost of that was to put some language in there on limitations and exceptions for copyright. This is known as the three-step test. It's not a very intelligent or illuminating solution, but dumb or not, it was a diplomatic solution that has now migrated throughout all areas of intellectual property law and will haunt us for the rest of our lives. This three-step test, limited, reasonable, and prejudice of legitimate interests. And the publishers, as I say, rather than purr, they attached this three-step test to practically every article, every important article of the treaty. So they just repeat it ad infinitum, as if the three-step test is always here to haunt your anything you do. Now, if you go back to the Stockholm negotiations of the Stockholm Treaty, they had to be adopted unanimously. And of course, all of the governments assembled there were very worried, what was this three-step test going to do to our limitations and exceptions? So the proponents of the rapporteur general, representing the proponents of this solution, were very deferential. And they got up there and made a full report saying, look, it will not affect any of your pre-existing limitations and exceptions. And then they listed them, and there was effusive, extensive description of the limitations for the blind, because they knew that would have been a delicate area. So what we have to do is to go back to that introductory text on the rapporteur general's text on the three-step test and consider it the magic words since at the WTO have become acquis. This is acquired rights. This is an acquired right of all states to maintain their past practices. And we have all of this material saying that nothing should affect the protections, the limitations and exceptions favoring the blind. Now, that, of course, was 1967. This is a treaty later in time, but it's also a treaty later in time supported by the Human Rights Clause. So my interpretation is, and I think this is what I tried to contribute, is that that combination cannot allow a serious application of the three-step test. It has to consider that these exemptions for the blind are rooted in history, are rooted in exemptions of the three-step test, and the burden is on the other side to show that there's some reason to curtail them in this treaty implementing the human rights side. And I don't think it will stand up, and I hope it won't stand up. And meanwhile, I think we should go forward and think about how to apply this this template, I'm going to be writing about this with Ruth on how to apply this to the problems that we have with compulsory licenses of pharmaceutical patents. What we need is a cross-border mechanism of supply. We now have the waiver, the amendment to the TRIPS agreement, and I think this could be a way of implementing that exception to TRIPS agreement. So congratulations.
So we have about 10 minutes or a bit less for questions. Happy to take them from, I see some of my students are in the audience, so I'm very happy about that. You heard about object and purpose of treaties. I told you, now you know. Any